The member focus group has been facilitating multiple sessions as per the request from the community on useful topics. And one of the areas where we've got consistent feedback or request is the area of copyright infringement. So as we all know, the issue of copyright and IPR is something that we deal on a daily basis. We try to address it in multiple ways. We get a lot of questions in this area from our clients, and that is why we wanted to conduct a discussion on this particular topic. And so today's discussion is on forensic technology of software copyright infringement. And we are extremely lucky and privileged to have one of the world-renowned speakers on this subject, Dr. P. Vinod Bhattacharya. He has over 33 years of experience in computer science and cybercrime forensics. He obtained his master's degree in operations research and computer applications and MPhil degree in computer science. And then he also has a doctorate in cybercrime forensics. He's already served as a technical expert to the police, judiciary, Directorate of Revenue Intelligence, Special Intelligence and Investigation Bureau of Department of Customs. He is considered as one of the leading experts in the world on evidential aspects of software copyright infringement crimes. Apart from these consulting assignments, he is voluntarily serving the state police chief, Kerala, as the chief technology officer, honorary IT advisor since 2018. He is also the developer of POSIR, which is a protocol for forensics of software copyright infringement, which is now used in Western judiciaries. He has also published several research papers internationally on forensics of software copyright infringement crimes. So we are extremely happy to welcome you, Sir Dr. P. Vinod Bhattacharya, and we look forward to hearing from you. Over to you, sir.
Thank you very much. So shall we start?
I think your volume is a bit low. Can you talk closer?
What about now?
Yeah, it's still a bit on the lower side. Are you using a headphone?
Yeah, I'm using a headphone.
Yeah.
And then there's a microphone here itself.
Okay. Okay.
What about?
Is it okay with everyone? I think it's. I can still hear you, even though the volume is a bit low.
Is that okay?
Vishnu, how about you? Is it okay?
It's okay with me. Yeah.
Okay. Then
Okay.
let's continue. Yes.
Is that okay? So I'll also speak a bit louder.
Okay. Thank you.
Yeah. So thank you very much for the proper introduction, and it's a great chance to meet several software developers in Kerala. I should say budding talents. Tomorrow, some of these companies are going to become world famous companies. I'm very happy to meet people from right now there are 24, including me. Great. So let's straight away get into the topic, because I've been given only 1 hour, just 1 hour, to present the whole thing and also to answer the questions. This field is an ocean. It's a very big area, and it's one of the my challenge today is to present the entire thing in the in a capsule form in just 1 hour, or less than 1 hour, I should say, maybe 45 minutes or so. Let's start straight away. Let me first share the screen here, some of the screens. Give me a minute. is the uh, is the screen visible to you?
Yes,
Yes.
sir.
Yes,
Yes, it's visible.
it's visible. Okay. That forensic technology of software copyright infringement, or you are seeing me on the screen or the?
No, we can actually see you as well as the presentation.
Okay, very good, very good. Thank you very much. Today's topic is forensic technology of software copyright infringement. Before explaining what is the forensic technology of software copyright infringement, we'll start with copyright and then move on to copyright infringement, and then we'll connect it to the forensic technology. That will be the easiest way to present everything in this short time. Um, well, what exactly is software copyright? See, uh, any intellectual property, including software under the sun, any intellectual property can be protected so that the owner will get the benefit during a long run. Say, for example, several years, maybe 50 years or 60 years or 70 years, or even more than that. Or the company will get more than, say, 100 years or 150 years. Uh, their intellectual work or intellectual input into the software, or just any product in the world, uh, is protected. Not just the intellectual input, but also the financial input, time, everything can be protected as a single entity. Accordingly, software can also be protected like that. uh, Remember, software can be protected under the copyright law of the country. uh, I haven't say I haven't say information technology law of the country. So software protection is coming under copyright law and not any other law, any other cyber law or any other thing. This is very important. And copyright law is applicable to all the products in the world. Say with not just for software. It can be, it's applicable for televisions, it's applicable for air conditioners, it's applicable for automobiles. So many products in the world. So just one copyright law in India, for example, in India, that's applicable to all the products in the world. So how does software fit into this? That's the biggest challenge, of copyright law. That makes the entire thing, entire what do you say, thing different from any other cyber related things in the world. Uh, m- okay, so let's. So, who can obtain copyright of a software? So, if you want to protect your software, you have to obtain copyright of that software. Who can obtain software? The software developer, that means the individual, can obtain copyright. The software developer company can obtain. The software marketing company can obtain copyright, or anybody else can obtain copyright. Now, this is a very, interesting thing. Say, for example, let me take the example of Suhail's. I know one person in this group, Suhail, I know very well. Let's take Suhail. His company Newcore is developing a software, travel agency related software. Now, for that software, who can take copyright? Your natural answer will be the second one. Software developer company Newcore can take. But interestingly, Suhail can take copyright of this. And Suhail's partner Mohandas can also take copyright of this product. And third thing, the company Newcore can also take copyright of this. So three copyrights for the same product. It's possible. And even including, I can also take copyright of that product. So four different copyrights for the same product. This is possible. Now, look at the last part. But in case of a dispute, whose copyright is considered valid? That's the most important thing. When there is a dispute, copyright dispute, whose copyright is valid? Suhail's copyright, or his partner Mohandas' copyright, or their company Nuco's copyright, or my copyright of that software? It's the author's copyright. That's most important. So who's the author? Is Mohandas the author? Is Suhail the author? Is Nucor, their company, Nucor, the author, or me, the author? Or a person, working in that company is the author, because the staff, it's a staff member or a group of staff members, who authored this particular software. So who is considered as the author of the software? Only author's copyright will be considered. Let's say, so who is the author? Author of the software is a person who developed the software. Did Suhail develop this software? Was it Mohandas who developed the software, or was it Nucor, the company, who developed? Which developed this software, or me, the fourth copyright owner, me, who developed that software? There, the difference is, if an employee creates a work as part of his employment, the employer is often considered to be the author of copyright purpose. Now, things have become very clear now, that I think my photo, my video is jumping. So if it is inconvenient to you, I can. Oh, that's okay. Never mind. I think there is some problem. Okay. So who's the author of the company? Who's the author of the software? The company is the author of the software. That makes everything clear. The real author of the that particular software is not Suhail, not Mohandas, and not me. It's a Nucor. So only Nucor will get the authorship of the legal authorship of the software, and not anybody else. Even though there are 4 copyright holders, all the four copyright authors can claim that they are the author, but judgment will be what do you say, prejudiced, or the judgment will be concentrated only on the authorship of the company, the employer, Nucor. How long does the copyright last? That's a big question. Suppose, say, your company has taken copyright for the software. How long? There's a big question. Life of the, normally the general rule is that life of the author plus a few years. So who's the author of this software? The example that we have taken just now, Nucor is the author. So long as Nucor is there in the market, plus a few years. If the author is a human being, if the author is a human being, in this case, company means a long time, say 150 or 170 years, if the author is a company, right? Now, years means, it's written plus a few years, means how much? It depends on the country to country. In India, it's around 60 years, 60 years in India, but it varies from country to country, so you have to check with each country, each country's copyright law. Just a minute, yeah. So is the screen okay now?
Yes.
Hello?
Yes.
Yeah, looks fine.
Okay. My only my face is not there. That's okay. Not that beautiful to present. Okay. Now, the next one. Does the copyright law protect all the components of a software? No. it protects only certain parts of the software. For that, the most important thing every software developer, every software engineer should know is that if you consider software as an expression of an idea, then idea of a software is not protected under copyright law. Even if you have taken copyright of a software, you will be when you are taking copyright for your software, you are generally under the impression that your idea is completely protected. But no, your idea is not at all protected. Only that particular expression of the idea is protected. What is this idea expression thing? uh, uh, okay, we are moving to that. What is this idea and what is this expression? How can you envisage it? How can you separate it? We are going to that point, but in between, the last part, look at the last part. But software ideas can be protected under trade secret law, and the utilitarian aspect of any software can be protected under patent law. These three, copyright law, trade secret law, and patent law, are the three different intellectual property laws related to software or any product in the world. So you need not you need not think only in terms of copyright law. You can think in terms of trade secret law or patent law also, because those are number two and number three. The most important thing is copyright itself, copyright law itself. But uh, I'm just saying that there are two more things related to that. But whatever forensic technology or any other things that we are going to explain from here onwards, whatever we are going to explain from here onwards are applicable to the trade secret law or patent law also. The engineering part or software engineering part, the forensic part, everything is applicable to that. So with that note, let me let me clearly explain what is this idea expression dichotomy of copyright laws, particularly in the area of software. So the since the previous thing says that uh, idea of a software is not protected, expressions are protected. So the copyright law is asking you to separate expressions in the software from the idea of the software, right? So how do you separate expression and idea from your software? It's easy, not a big thing at all. I can give three examples. uh, first thing is that any idea can be expressed in different ways. You know very well that say take the first example, two different expressions of the same idea. Here the idea is obtain the square of a given number. You want the square of a given number, you give a number, you want the square of that. Now here are two different ways in C++ to obtain square of that. Take the first one. It's a function square of a number, and input is p, which is an integer, and the output is also an integer. There the first variable is int square, which has been made to 0, initialized to 0, and then there is the input p, p star p, which is assigned to the variable square, and return square. That's the first part. And the second part is return p star p. So two different. There is could you please mute your yeah, I think he has muted. So these are two different expressions of the same idea. Right. Now look at the last one. These two expressions can be separately protected under copyright laws. So in one software, if the first expression is the main is included, and in the other software the second expression is included, both are separately copyrighted, and both will get main copyright. Both can be covered under copyright law. Right. Now, whether when in the case of a dispute, will these two things be considered as a single thing is a different aspect which we will consider later. Now, example 2, three different expressions of the same idea. Idea is software for travel agency. Three different expressions of this idea. One is tracks by Newcore Kozhikode, another one is e-travel by Infodynamics UAE, next is trams by Trams USA. I'm just taking three examples of travel agency packages across the world. There are three different main expressions. In fact, there are several packages across the world, around the world, for software travel agency. I'm just taking only three things, and these three expressions can be separately protected under copyright laws. Remember, when says, for example, the first one, tracks by Newcore Kozhikode. If Newcore goes for copyrighting this, but or taking copyright of this particular software tracks, uh, they have to apply for that. They will get it, but it doesn't mean that nobody else can create a software for travel agency, because software for travel agency is the idea which is not protected. Only this particular expression, the expression of that idea done by Newcore is protected, and not the idea. So anybody else the world can create another software for travel agency, absolutely no issue. So this is example 2. Now take example 3. I mean, uh, you take the idea of cryptocurrency. There are at least 400 plus different expressions of this idea. Bitcoin is there. So many other. I've shown only 5. Cryptocurrencies. There are 400 plus cryptocurrencies in the world. They're all expressions of the same idea, that is cryptocurrency. Now, say first one in the lot is Bitcoin, and that's which is the most popular cryptocurrency in the world. They have created, and they are ruling the world. Doesn't mean that other people cannot start their own cryptocurrencies. Anybody can start a new cryptocurrency, and thus it's growing. The market is growing. So many new players are coming in. Right. So just because Bitcoin has copyrighted their product doesn't mean that nobody else can enter into the cryptocurrency market. Now, next is what all elements are covered in this copyright. In your software, there are literal elements and non-literal elements. For example, literal elements are source codes or executable codes. Non-literal elements are program structure, user interfaces, menu command hierarchy. Main say the literal means something which is what do you say, the meaning of that can be what do you say, understood by reading it, whereas non-literal things means the meaning of things can be either by reading or by watching it, because menu command hierarchy, for example, you are given a source code of menu given hierarchy. It's a bit difficult to understand the how does it what is it appear on the screen, when it is shown on the screen, when the menu command hierarchy is shown on the screen, you get a clear idea about that. So it's visual. It has got a visual effect also. So something that has got visual effect are called non-literal elements in your software. The other things are called literal elements in your software. But ultimately, as software engineers, you and me know very well that everything in the software it can be reduced to literal, because everything is code in it. Even non-literal elements, the thing that is behind non-literal elements, is also software. For example, menu command hierarchy, what is displayed, the menu command hierarchy that is displayed on the screen, what is there behind it? It's a source code. So that's again literal element. Okay, so what all expressions are not protected under copyright law? This is the turning point of this particular presentation. Uh, the most important thing, or the most important thing that has to be understood by a software engineer or a software developer, is that even if you have taken copyright for the entire software that you have developed, that copyright is not protecting certain things in your software. Just because you are saying that, okay, I have the copyright of this particular software, doesn't mean that you have protected all the elements in the software under your banner. No, there are several elements in the software which you cannot protect. What are they? Any standard procedure used in the software is not protected. That means any standard procedure used in the copyrighted software is not protected under that copyright. The second one, any standard method of operation used in software is not protected. Okay, what is the? I should give an example for the first one. Any standard procedure used in the software. Say, for example, suppose you are using a particular OCX file, which is common, which is supplied by Microsoft or some other company, and suppose you are using it during your software development. That's not protected because it's there in the public domain, or it's done by somebody else. It's not your product, but it's used in your product. So that your copyright does not cover that particular OCX file. And next is any standard method of operation used in is not protected. Any standard mathematical concept used in the software is not protected. For example, suppose you have used say the formula to calculate the circumference of a circle, say 2 pi r, where r is the radius of the circle. If you have used that particular mathematical formula in your software, that's not protected because that's not your product. That particular mathematical formula, it's a common thing, public thing, which you have used in your software to calculate something, doesn't mean that the copyright that you've taken for your software includes this mathematical concept. No, it's wrong. So such things. Now let's look at a bigger list. Let's expand this list. Specifically, these are the unprotectable elements under the copyright law. For example, one globally common mnemonics. Mnemonics means all the variable names, say for example, I, J, K, or account name, account number, or something like that. All the short forms used in in it. All the globally common mnemonics. Say variable I, variable J, or say for example, let's take this. Say there is a variable P, there is a variable square. All are very common in the world. If these variable names are there in your program, they are not protected. They will not get the protection that you expect. Then the next one is globally shared notations. There are several notations that are globally shared. For example, pi, the value, the mathematical concept by name pi. uh, Normally we write either pi, or there is a character used for pi also. Those notations will not, if those notations are there in your software, they will, copyright is not extended to those notations. Codes or expressions due to shared nature of the globally common functional area jargons. You all work in different functional area. For example, new core, the track software is, the functional area is travel agency. Now, sometimes a functional area can be medical, say hospital management, or say banking, or some other, so many, or jewelry, so many different functional area. Now, say for example, or accounting for that matter. uh, Now, what do you mean by functional area jargon? For example, account number. In accounting, account number is a functional area jargon. When I say, when an accountant says account number, he knows what he's speaking about. So that's a jargon. And you tend to create variable as ACCNO, or ACC underscore NO, or ACCOUNT underscore NO. These are all different variable names that can be created from account number, which is a jargon in the functional area accounting. None of them will get coverage of copyright law, because they're all um, functional area jargons. And anybody who is in that functional area, whether an accountant or a software developer in New Zealand or India or United States, they all use a account number as a jargon in that field. And they all can create those variable names. So these are all not extended to the to those jargons, or variable names, or function names uh, created out of those functional area jargons. Then the fourth one is codes expressions due to shared nature of global software education. For example, say, suppose that, say, when I did, when I did the master's degree in computer science, 30, how many years? 34 years ago, there were 11 classmates. All of them, all these 11 students studied the same text. We attended the same class. We tend to develop the same style software. And we attended the same examination. uh, because of these things, we tend to use certain common world common expressions, or certain expressions, or certain algorithms which are found in the textbooks, or which our teacher, our professor explained in the class. So many common things are there among the 11 students. But uh, so big, is if there is any such common thing appearing in the software that is developed by you and copyrighted by you, then those expressions or codes will not get the benefit of that copyright. Fifth one, materials that are available in the public domain. For example, say, let's take this, the logo of this Bitcoin. So if you're using Bitcoin in your software, in your the accounting part of the software, suppose Bitcoin is there, and if you're using this logo, mean uh, will the copyright taken for the software be extended to this logo? No, it will not be extended to that logo. So because this logo is available in the public domain. Similarly, there are several OCX files or several such standard uh, what do you say, functions, standard procedures available in the public domain. And if you have used those things in your software, the copyright that you have taken for your software will not be extended to those materials. The sixth one is codes expressions which are unique or idiosyncratic to the idea expressed. That means merged expressions. This is very important because you can have several confusions here. So I'll explain what is a merged expression. See, merged expression is not a computer science word. It's not a computer science, although we are talking about software or software engineering. Merged expression is not a computer science word. It's a legal word, or it's a copyright related word. Not even lawyers who are not specialized in copyright law, uh, they won't understand what is a merged expression. Only people who are only lawyers who are specialized in copyright law will understand what is a merged expression. I'll explain merged expression uh, in terms of software engineering. Okay. uh, for that, let me go back to this. Now here the same idea has been expressed in two different ways, right? Is there a third expression? Can this be expressed in a different way? Or how many different ways this can be expressed different from these two? Only two or three additional ways, right? There are only two or three additional ways. Other than these two, there are only one or two or three additional ways, which means that this idea can be expressed only in two or three different ways, or two or three or four different ways. That means this particular idea can be expressed only in a limited number of ways. Limited means small number, either two or three or four, something like that. Unlimited number of ways means this can be expressed in 20 different ways, or 30 different ways, or several different ways. That's unlimited. uh, if an idea can be expressed only in a limited number of ways, say in only in two different ways or three different ways or four different ways, that means only a limited number of ways, then copyright law says the idea and all the limited number of expressions are merged together. They are called merged expressions, or expressions that has been merged with the idea. And all these things together are not protected. Why? There's a big question why they are not protected. Because this particular idea can be expressed only in, say, for example, four different ways. For example, I obtain the square of a given number. In suppose this idea can be expressed in C++ only in four different ways. The first person to use this can take the first way, and he can take the copyright. The second person can use the second method, and he can take the copyright. Third person can use the third method, he can take copyright. Fourth person can use the fourth method, he can copyright his software. What will happen to the fifth person who wants to obtain the square of a given number? He won't be able to use any of these four, because all these four are copyrighted. Such a thing should not happen in the market. That's why if any particular thing can be expressed only in a limited number of ways, then all these limited number of ways are merged together with the idea, and all these things together are not copyrighted. So this is what is called merged expressions, and that's why it's not copyrighted, because this otherwise it will create a monopoly in the market, and monopoly in the market is not it's not fair justice. So they are not copyrighted. Merged expressions are not copyrighted, or the copyright that you have obtained for your software is not extended to any of the merged expressions in your software. The seventh one quotes expressions that are part of the compatibility requirement with another program with which this program is required to interoperate. For example, say the travel agency software, say Suhail's or new course software that we have this one tracks, the first one, tracks by new core code. This tracks may have to work or may be interoperable with some other packages in the world. uh, uh, with if those packages are absent, say for example, whether I don't know whether it's connected to CETA package or any other ticket booking, airline ticket booking package in the world. If that is not working, this package will also not work. uh, so there is this package will have some interoperability with some other package. uh, the particular function that is used to make it interoperable, if that is used in tracks, the copyright obtained for tracks is not extended to that particular function that is used for interoperability. That's the seventh one. Codes expressions that are part of the compatibility requirements with another program with which this program is required to interoperate. That's not protected under copyright law, or the copyright that you have obtained for your software is not applicable to this particular code or expression. Now, now let's go into copyright infringement. The copyright laws legally protect the author from literal copying of his or her software or non-literal copying of his or her software. What do you mean by literal copying? Your copy paste is literal copying. Disk to disk transfer is literal copying. What is non-literal copying? Say for example, um, uh, say I have a software, I have written a software, and you want to see that software, you want to see the source code of that software. So I can show you the source code. I will not give a copy of that source code to you. I can show you the source code. You can just go through the source code. Oh, this is the way you have implemented. And then you are writing your own source code. So you are taking cue from my source code and writing your own source code, and you are marketing it. That is non-literal copying. Both are not permitted. Both are not permitted. So non-literal copying is learn one idea and it's one expression, and express this idea in his or her software by paraphrasing the expressions, making small changes. That's what's called paraphrasing, phrasing, making small changes, and then you implement in your own way, but only by making small changes in that. But you have not obtained a copy paste of that, a literal copy of that thing, or you don't have that thing with you. You had a chance to go through the source code of some other software, and you went through that, and then you make your own source code, but that is also considered as copyright infringement. So literal copying is also considered as copyright infringement. Non-literal copying is also considered as copyright infringement. Now, in case such a thing happened for your software, that means illegal piracy of infringement of a copyrighted software, sorry, illegal piracy, or I think it's my mistake, it's not of, it's or. Illegal piracy or copyright infringement of a copyrighted software can lead to a litigation under copyright laws. Remember, lead to litigation under copyright laws, not under any other laws, because copyright means copyright laws. You have been given copyright of a particular software under the various sections of the copyright laws and not under the various sections of any other laws. So litigation under copyright laws. Nature of violation. In what are the different ways your copyright can be violated by somebody else? Literal copying of literal elements in the software. That means just when your software, suppose your software contains 100 lines, and you have taken copyright for that software. Just copying these 100 lines and pasting it in pasting it in my terminal, that is literal copying of literal software. Non-literal copying of literal elements in the software. What is that? I had a chance to go through your 100 lines in the software. I understood the way in which you have implemented it, and then I write my own source code, but I have taken cue from your source code. That is what is called non-literal copying of literal elements in the software. That's also a violation. Literal copying of non-literal elements in the software. What is a non-literal element in the software? Let's look back. See, non-literal elements. The program structure is a non-literal element. User interface is a non-literal element. Menu command hierarchy is a non-literal element. So, for example, your software is running in some organization. I went there. I have seen the menu command hierarchy of your software in detail. I've gone through all the menu command hierarchy. You have a very peculiar style of menu command hierarchy in your software. And then I'm coming back to my development center. I'm creating a menu command hierarchy for my software, almost similar to your, or maybe some changes. By making some changes in that, that is also violation of copyright. Then the fourth thing is non-literal copying of literal elements in software. Sorry, non-literal elements in the software. That is, say, what do you mean by non-literal? You taking an idea, taking only the idea, or I got some idea from your menu command hierarchy, and I am just implementing that idea in my own way. But that is also violation. So literal copying of literal elements, non-literal copying of literal elements, literal copying of non-literal elements, non-literal copying of non-literal elements, they're all violations. Remember, when there is a dispute, all these four violations are to be proved, or at least one of these violations has to be proved. Then only you will get the benefit of judgment, or your judgment. Then only we can say that judgment is favoring you. So if you want to get benefit of that, it's the duty of the lawyer to present or to look at the copyright infringement and find out evidence of these four. Excuse me. Find out the evidence of these four. Now, can a lawyer take evidence of these four things? No, only software people can take. Only a forensic expert specialized in copyright infringement can take evidence of these four things. Lawyers can't take evidence of these four things. So first of all, evidence of these four copyright infringements are to be taken from the software with the help of a forensic expert specialized in copyright infringement, not just any cyber forensic expert. There are several cyber forensic experts. Some of them are specialized in network forensics, some of them are specialized in image forensics, some of them are specialized in various other forensics, but most of them are not specialized in copyright infringement. People who are specialized in copyright infringement are to be chartered first, then take evidence of these four copyright infringements, and then properly present it to the lawyer. And thereafter, the lawyer has to present it properly in the legal way in the court. Then only you will get a favorable judgment, right? So if you feel that the judgment in a particular case, in a particular copyright infringement case, is not favoring you, then it means that you have not presented or the evidence of these four things properly to the lawyer, or the lawyer has not presented these things properly in the court. Garbage in, garbage out. You will get an unfavorable judgment. Uh, Forensic steps in software piracy litigations. First of all, engage technical expert. Then, what I'm saying is, what does a court do if you have approached court with this? Court has to engage a technical expert, because this is not in the what is a in the specialization area of a judge or a legal expert. So technical expert is very much important here. So court has to engage a technical expert, then obtain a copy of the original and the allegedly pirated software. Both are to be obtained. Now if you have obtained, sorry, if you have lodged a complaint, then your software, the copy that you have with you is original, and the copy that is there with the pirate is the pirated version. Now you may submit the original voluntarily in the court, so I don't have to come to your place and obtain your copy. But if I am the technical expert, I will have to go to the pirates soft company or home or wherever, and then obtain his version of the software, the pirated version of the software. Then select a forensic protocol for comparison in order to establish copyright infringement. Using this protocol, compare the original and the pirated, and then fifth one, report to the court that these and these are the pieces of evidence of piracy. Just report to the court that these and these are the evidence of piracy. That's all. The rest lawyers will do, or the judge will do. That's the thing. And there are several tools available. Automatic tools. There are two different types of tools. One is automatic tool. One is manual tool. But remember, in everything in the world, in almost all the forensic areas in the world, automatic tools will work. The manual element in the investigation is very, very, very less. Something like 80% of the thing will be done by software tools, 20% manual. But in this case, although these 6 tools are available, they can do the job only 20% or 30% maximum. The rest, 70 to 80% jobs are to be done manually. So there are manual methods available. One is AFC, or abstraction filtration comparison test. It was enforced by the US judiciary in 1992, and it's still in use. It was developed by Dr. Randall Davies of Massachusetts Institute of Technology, USA. And the second method, the POSAR, or planning, operationalization, separation, analysis, and reporting test, POSAR test. It's a fairly recent one. That means the 2012 one. It's a developmental extension of AFC. It's an extension of AFC. There are certain areas where AFC can fail. In those areas, or if there are those areas in your software, then POSAR test has to be used, and it is developed by me, developed by Dr. Vinod Bhattacharya. It's still used in the US judiciary. This is the AFC test. The first one here, the second test, AFC test. It can be presented like this. It's a linear sequential thing. There is phase 1, and there is phase 2, and there is phase 3. Okay, but the POSAR protocol is cyclic by nature. So it's look at the thing. It's cyclic. Start, planning phase, and planning phase. It's all so from here, any error, no, then go to the operation. So it's cyclic. There are several reasons for this to be made, or this made cyclic. There are several reasons. If we get a chance later, we can explain all these things. There are several advantages for this manual comparison, but remember, 70 to 80% of the forensic job has to be done manually in this particular case, and that's why only people who are specialized in copyright forensics or digital copyright forensics can do this job, because there is a lot of manual work involved in this. And this is my book. You can refer to this book, Judiciary Friendly Forensics of Software Copyright Infringement, the book that I've written. Right bottom you can see IGI Global. It's an American book publishing company based at Pennsylvania. Hershey, particularly, it's in the town by name Hershey. You must be knowing what is Hershey. It's a very famous city for chocolates, Hershey chocolates. Several different companies are there, but there is a peculiarity for chocolates produced from Hershey, the city of Hershey. This company is also there in that. This book is available in Amazon.com. You can purchase that, and you can read that if you have any further. And this book was displayed in the Frankfurt Book Fair, the biggest book fair in the world. In 2015, this book was there. On the right hand side, you can see the photo on the right hand side, second row, last book was this particular book in the Frankfurt Book Fair. Thank you. Any questions?
Is there any order in which people can answer or ask questions or anything like that, or someone has to raise their hands?
No, you can ask. You can start.
Okay. One main question from my side is, it's about requesting for a copyright. Get the software get copyrighted. What all documents?
Could you please be a bit louder?
Okay. So one of my first question is, for just getting it, the software copyrighted, what all things we have to present? Is it the code or the screenshot, or is there any process for that?
Okay.
Or is it
Okay.
specified on your book?
That's a good question. You consult a lawyer specialized in copyright law.
Got it. So,
A lawyer specialized in copyright law. I am a software engineer specialized in copyright forensics. Only lawyers specialized in copyright law can. Where are you talking from?
I'm talking from Cochin itself.
You're talking from Cochin?
Yeah.
Okay. Should I suggest somebody?
Please, yeah, that was my next question.
There is one person by name Hari Kumar. I think his office is in Tripunithura. One lawyer by name Hari Kumar, or there is another lawyer by name Binoy Kadavan. Both of them are specialized in copyright laws.
Got it. Okay.
There are several others also. Several other good lawyers specialized in copyright laws. These two names have just come up, so that's why I'm sharing with you.
Okay, so I think if we search on Google, we might be able to find it. Is it?
I think I can give their telephone number.
Yes, please. Yeah, if you can share. Yeah.
Email, you can send an email to me. I can share their numbers.
Oh, great. Okay, great.
Yeah.
Thanks. Yeah, and the next question is this copyright taken in over here? Is it valid in all the countries, or is it specific for?
No. See, okay, now, okay, your question is, I think I have to restructure my answer. Your question is, copyright taken from India is applicable in the US?
Yeah, or any other country.
Or any other country?
Yeah.
Yeah, that's valid.
Okay. Yeah, that was my question. But third was, approximate cost. Anyway, that only the lawyers might know, just to get an idea. Okay, that's fine. Yeah, thank you very much. Yeah, it was very informative and helpful. And I think some of this information might be in your book also, is it?
Yes.
Great, thanks. Thank you. Thanks.
Or you can contact me through email.
Thank you.
I can answer that.
Yeah, if you can share your email ID in this thing, that would be helpful.
I think I have given permission to Suhail and Vishnu to share my email address with everybody.
Great, thanks. Thank you very much.
Thank you.
Hi, Dr. Vinod Patadiripat. This is Dinkar Krishnan from Elmong. I'm based out of Trivandrum. My question is related to one point that you mentioned. Where
please be a bit louder.
Yeah, so you mentioned that an author is protected from literal or non-literal copying. So somebody has a look at my source code or the menu hierarchy, the structure, etc., and he develops his own code, or he based on that, the copy of the expression. So that is one scenario. The second scenario is somebody develops without that, without probably having a look at my code, but it is almost similar to my code. So isn't it? So is it like the burden of proof is on me to prove that, okay, he has copied, or how does that work in that kind of a scenario?
Okay, the first one is intentional and the second one is unintentional, right?
But who will eventually get the the copyright? I mean, how does me as somebody who has done it first?
Both will get copyright. Both can apply for copyright. Both will get copyright. And supposing that you came to know that his software, or you suspect that his software is a copy of your software, So you go to court. So a dispute starts. Now my court has to compare these two and find out whether it is intentional copying or non-intentional copying. Court has to find out with the help of a technical expert, and that's the procedure.
Thank you, sir. Thanks for the response.
Yeah.
So Vishnu here. So there is a question from Mr. Jacob.
Hello.
So yeah, Vinod sir, can you hear me?
Yeah. I can
Okay,
hear
okay.
you.
Yeah. So there is a question from Mr. Jacob.
Yeah.
So he has asked, like, for buying a software from a company with source code, if a copyright lawsuit develops, who is the rightful author?
When you if you have or when you during the purchase, you will have a lot of agreements, right? Purchase agreements. In that you can include this also, and then you can take the copyright. After the purchase, you can take the copyright, and you will become the owner. The purchase agreement has to be proper.
Okay. So I hope Jacob is clear with that.
I hope.
Yeah. So is there any other query or question from the participant?
Hi, sir. This is Dinkar here again. I mean, 1 hour is too less a time to get a complete grip of the topic and to understand.
That's
But
true.
could you just give a sense of what could be the strategy? I mean, what is the time that companies should seriously, especially when we look at startups, that are trying to grow? What is that point of time that they should consider taking this seriously and account for probably some budget, and what is that stage that you would recommend that companies could seriously think about this, or probably they are just developing a prototype or a proof of concept? Probably we don't need to look at this aspect, but when do you recommend?
No, there you are wrong. The last sentence, you start taking copyright from the scratch itself. When you reach a small landmark point, you take copyright of that, and at the second landmark you take again copyright of that. At the third landmark you again take copyright of that, because taking copyright is a very cost effective thing. Only a very small amount is involved in taking a copyright.
I was coming there. I wasn't too sure how the costing works for that. So yeah. I think I got the answer.
Yeah, it's a very small amount. So at the very prototyping stage itself, you take copyright of that prototype, and then implementation, the next landmark stage, you take copyright. So by the time you take, say, 1 year or 2 years to completely develop the package, you will have several copyrights, and the final copyright is considered as the copyright of that software.
So the subsequent versions become an update of the already copyrighted versions, or how does
No,
the
they're all different copyrights.
okay.
But if so the final product, when you submit the final product and apply for copyright, and when you get the copyright of that, you yourself will tend to neglect all the previous copyrights. Right.
Thank you, sir.
Any other question?
So if there is no other question from the participants, let us move on to the vote of thanks. Suhail, you are there, right?
Yeah, yes.
Okay, so I think there are no other questions from the participants. So I think that we have actually reached the time also. So
Yeah,
it's
yeah.
now your turn for the vote of thanks. So over to you, Suhail.
Okay. Thanks, Vishnu. Thank you, sir, and thank you, participants. I think, as I know, sir, for the last couple of years, and it's still, yeah, I was learning a lot of things from him. But again, today's session, as I really feel that it has been triggered most of our thought process, or I think in a very short 1 hour of time, he has explained a large subject, and he tried to make it cut short, but it should be there are enough takeaways for all the growing and grown-up companies in Kerala. I think they should actually be aware of and actually be well aware at the very early beginning stage of their venture itself. So this has actually I would thank Dr. Vinod Bhattatripad sir for making this session in such a short but very informative and very triggering way, so that most of us, from the question we can see that most of us started thinking about how to look at, because there could be a lot of assumptions that having a copyright registration alone will be, I'm safe with my software assets. But now only we are going to see how we should go, or how we should approach the things the moment itself we find out a copyright infringement, whether it is emotional approach or whether it is a factual approach. So we should be ready with all these things well in advance. And in that aspect, I think the session was very, very useful, and the session made us, gave us a lot of thoughts. And sir, I officially take this opportunity to thank on behalf of GTEC for coming and giving us a very informative session. So please accept our great thanks on this behalf of GTEC, and especially to the participants who made this session they listened and they made it very interactive during the Q&A and joining on time, and appreciate all the participants of the GTEC member and non-member companies, and thanks a lot for joining on time. And I think the initiative taken by members focus group of GTEC is actually, it's appreciable, because whatever required for the growing companies here is actually they are looking for such sessions, and they are making so many such useful session. And this is one of the best session I feel very useful for these members, and a special appreciation and thanks to member focus group, and again to all these members who participated. And thank you very much.
Thank you.
And thanks to all. Jishnu.
Yeah, Suhail.
Yeah. So.
Okay, so I think with the permission of Dr. Vinod Bhattatripad, I can actually share your email ID with the participants, no? If they have any separate queries.
Yes, please.
Okay.
Yes, please.
Okay.
Yeah.
So, yeah. Okay.
Definitely.
Okay. So
Fine,
thank
fine.
you very much. Shall I leave?
Yes.
Thank you.
Thank you, sir. Thank you so much. Thank you all.